the judgment of Navtej Singh Johar versus Union of India 2018. A writ petition was filed on 26th April 2016 by Navtej Singh Johar, a dancer from the LGBT community, that is lesbian, gay, bisexual and transgender community, along with four others, to challenge the constitutional validity of section 377 of IPC, which criminalizes consensual sexual intercourse between same-sex adults in private. In the prayer, the petitioner prayed for declaration of right to sexuality, right to sexual autonomy, and right to choice of sexual partner to be a part of right to life guaranteed by Article 21 of the Constitution of India. It was also prayed by the petitioner to declare Section 377 of IPC as unconstitutional. Procedure history, which was established by the Delhi High Court in 2009, is in July 2009, the Delhi High Court declared deemed portion of Section 377 as unconstitutional in Naz Foundation versus Government of NCT of Delhi. However, various individuals and religious groups challenged the judgment, and the Supreme Court overturned the Delhi High Court judgment in 2013 in Suresh Kumar Kaushal versus Naz Foundation, saying that the matter and decision be left up to the Parliament. The matter of Section 377 was rejected in 2015. So here the Supreme Court has given its view that the Supreme Court not have the power to repeal the section, as the section has to be repealed by the government by making the law. Arguments raised by the respondent are in Navtej Johar Singh versus Union of India. First argument is Section 377 of IPC does not violate Article 14 of the Constitution, as it merely defines a particular offence and its punishment, and it is well within the power of the state to determine who should be regarded as a class for the purpose of the legislation. And second point, Section 377 of IPC does not violate Article 15 of the Constitution, as the said article prohibits discrimination based on religion, race, sex, place of birth, caste, and not specifically sexual orientation. And third point is, person indulging in unnatural sex acts made punishable under Section 377 of IPC are more susceptible and vulnerable to HIV, AIDS, and right to privacy cannot be extended to enable people to indulge in unnatural offences and thereby contracting HIV AIDS. Fourth point is, the offence under Section 377 of IPC implies sexual perversity and involves carnal intercourse between two persons, which is offensive, injurious, and against the order of nature. It is well within the jurisdiction of the state to put reasonable restrictions on it. Section 377 of IPC has been incorporated after taking note of the legal system and principles which prevailed in ancient India, and the said section is more relevant legally, medically, morally, and constitutionally in the present situation. And sixth point is discriminalization of Section 377 of IPC, which sample the family system and determinantal affect the institution of marriage, open to floodgate of social issues which the legislative domain is not capable of accommodating, and would also have a cascading effect on existing laws. Basing on the facts, court framed issues, that is, whether Section 377 of IPC violates right to equality under Article 14 of the Constitution, and next issue is whether the Section 377 of IPC violates freedom of speech and expression under Article 19 of the Constitution. Third issue is whether Section 377 of IPC violates right to life with dignity under Article 21 of the Constitution. And fourth issue is whether discrimination based on sexual orientation under Section 377 of IPC violates Article 15 of the Constitution. And the final issue is, was the rationale of the Supreme Court judgment in Suresh Kumar Kausal case sound its understanding of morality as a social morality? The bench found that Section 377 discriminates against individuals based on their sexual orientation and or gender identity, violating the Article 14 and 15 of the Constitution. Further, they held that Section 377 violates the right of life, dignity, and autonomy of personal choice under Article 21. Finally, they found that inhibits of LGBT individual ability to fully realize their identity by violating the right to freedom of expression under Article 19(1)(a). They all referred to court's recent judgments in Nalsa vs. Union of India recognized transgender's identity, and Justice K.S. Putty vs. Union of India recognized fundamental right to privacy. In 2013, in Suresh Kumar Kaushal vs. NUS Foundation, the court had upheld the Constitution of Section 377. Not only did the bench find that Suresh Kausal failed to recognize how Section 377 violates fundamental rights, but further it relied on the constitutional reasonable rationale. Suresh Kausal used the minuscule minority rationale, which hold that since only small minorities of citizens are negatively impacted by Section 377 of IPC, the court need not intervene. The Constitution guarantees all citizens, independent of sexual orientation or gender identity, their fundamental rights. The court is concerned with safeguarding constitutional morality, not popular morality. It does not matter how minuscule are the lesbian, gay, bisexual, and transgender LGBT section. They also have the right to privacy, which includes physical intimacy. The choice of partner might be different, but it does not mean they will be prosecuted for that. Section 377 does curtail their human dignity and their personal choice, therefore violating their right to privacy, which is covered under Article 21. The main object behind retaining Section 377 is to protect women and children from being abused and harassed by carnal intercourse. But consensual carnal intercourse, which is performed by the LGBT community, is neither injurious to children nor women. Moreover, non-consensual acts have already been referred to as an offence under Section 375 of IPC, which implies that Section 377 is redundant and discriminative towards one section of the society and is therefore violative of Article 14 of the Indian Constitution, rendering it unconstitutional. Our Constitution being liberal, it is not possible that right of choice will be absolute. Therefore, some restrictions have been imposed on the principle of choice. However, right of choosing a partner for intimate relations is completely a matter of personal choice which cannot be restricted, whereas Section 377 of the Indian Penal Code restricts the right of LGBT community of choosing a partner for sexual matters and is therefore irrational and arbitrary. Public order, decency and morality are the grounds which can impose reasonable restrictions in the future. Thus, the five-judge bench of the Indian Supreme Court unanimously held that Section 377 of the Indian Penal Code 1860 insofar as it applied to consensual sex conduct between adult in private was unconstitutional.